deprived of subways and buses that they need. And I want to say, this was a very, very long process. Decades in the making, if you want to be honest, and multiple years of making sure the final bill was passed into law. There was, I will admit, significant things that have happened in the world from 2019 until now. However, nothing significant happened between the time the governor last supported it internationally, saying how great it would be when we get it done, and 2 weeks later when she said we're not doing it anymore. There was no new information, nothing new had happened. And I'm also going to be honest, like, I come from a family of drivers, and I understand it is important, but that cannot be on the backs of the masses of people who mostly travel with mass transit. We have to make sure that public transportation is paramount. And I understand everybody wants things to change. They sometimes just don't want it to change, particularly if it affects them. We cannot complain about the traffic. We cannot complain that our transit system needs money. We cannot complain about how bad our climate is with the hottest day on record and say we have to change it and then say we can't change it. We just cannot do that. Now, I agree, and I will say that it wasn't, no plan is perfect, but I don't see a time ever that is going to be perfect to implement this plan. There's going to be, whenever we do it, someone complaining. The best thing to do is get it started, and we tinker as we go along. We'll fix it as we need to. But in order for that to happen, we just have to get it started. We have to have the political will to get it started. We actually had the political will. We followed every process. We went through every legal thing that was put in front. So to have the governor try to unilaterally stop this is not okay after every process was followed, and we're lifting up the vast majority of people who travel to the city, who are low income, who are working, who will not pay any kind of extra fare to get to and from the city for work, to be stopped by unilateral one person who we believe doesn't even have the legal authority to do it. So I want to say thank you so much for getting this done. And on behalf of most people who travel in this city, we got to win this one. Thank you so much. Peace.
Thank you, Public Advocate. Let's see, I neglected two thank yous. First, the person I've worked with maybe the longest on some of these environmental issues is Eric Goldstein from Natural Resources Defense Council. And also, last time we were here, we stood with Michael Gerard, who's a law professor at Columbia, who's out of town today. And while he is not one of the filing attorneys on these two lead suits, has been the chair of the legal advisory and working group and an essential part of this coalition. And we're very grateful to Mike Gerard in absentia today. Yeah, one more time. Let's hear it one more time for this great coalition, for the fact that we promised that these lawsuits would get filed and that they are filed, and for the better mass transit system that all New Yorkers deserve and that we will have when congestion pricing is implemented and those investments go into place. And now we'll be very happy to answer your questions. So the Comptroller's office is not a plaintiff in either of these suits. The lawyers have worked to find plaintiffs with clear standing, and City Club, Riders Alliance, Sierra Club, and New York City Environmental Justice Alliance do, so we're not a party to either of these. There is research still underway on several other potential claims, including accessibility and civil rights issues, so there's still some research, and there may well be a suit there. There's some research underway on potential amicus briefs, and the lawyers are having conversations with potential filers there. We still do not anticipate the Comptroller's office being a plaintiff on any of the forthcoming lawsuits. We're, pleased to have been able to play this coordinating role to help bring people together to move things forward. That's a good opportunity for me just to clarify, no taxpayer dollars are being spent in the preparation or filing of these suits. The organizations that are bringing them and their legal teams are working together to provide the resources. I've spoken with the governor a few times since this coalition commenced, and those are good conversations. I have, respect for the governor. We have strong disagreement on this issue for sure. The most recent time I was in a meeting with the governor was when we acclaimed Kamala Harris as the Democratic nominee, as New York's Democratic nominee. I'm a delegate, so that was on the electoral side. Obviously, that's a place where we are wholeheartedly and fully in agreement. On this one, we've made clear our disagreements and have a respectful dialogue about it, and the legal process is commencing today to implement the law as required. The lawsuits don't speak to the specific fee. They call for the implementation of congestion pricing as required by law, but they do not speak specifically to the tolling structure that had been agreed to. I mean, when you've got a coalition of litigation, they agree on what's in the filing for the purposes of the filing. So what people agree on here is that the law requires the implementation of congestion pricing.
So I'll take the first question. And so this is Troy Ledeen for Earth Justice. As for the novelty of both the CLCPA, the law, and the Green Amendment, the constitutional amendment that gives us a right to clean air, it's true that those are novel legal developments, right? These are recent things that our legislature and the people of New York have done. But I think this is an excellent backdrop on which to highlight just how powerful these protections can be, because there might be edge cases in the future as these issues are litigated, but this specific issue, congestion pricing, there's no controversy over whether or not it's essential to reduce greenhouse gases, and there's no controversy over whether it's essential to get us clean air. In fact, in the Traffic Mobility Act that establishes congestion pricing, the legislature specifically calls out the air pollution that is happening with the lack of congestion pricing. So I don't think these are close questions in this case.
Hi, it's Andy Celli for the petitioners in City Club. No, the litigation is not going to slow anything down. It's going to speed things up. This is an Article 78 proceeding, which is an accelerated proceeding. The judge will set the schedule. There really are no facts that need to be developed. There's not going to be a trial with witnesses and all the things that go into making litigation go on forever. This is a legal issue. We're filing the papers today. The other side will have an opportunity to respond, and we'll have some more papers to file, but I would expect that we will be in front of a judge arguing this in September.
Look, there are a lot of reasons why congestion pricing needs to go into effect immediately. First, it's been 15 years getting here. Had we done it 15 years ago, we would already have more accessible stations and more signal replacements and more on-time trains. And the longer we wait, the longer all of those things will happen. When crews that were planning to do a project demobilize, that project slows down. So there are many reasons why this needs to move forward promptly. Obviously, building the political will and the coalition is always challenging, and when something happens to disrupt it, of course, it means that the whole thing could fall apart. That's why we have long said that while the governor calls it a, quote, indefinite pause, we fear that it could in effect be the cancellation of congestion pricing, and that's why we're bringing these lawsuits. What various circumstances could cause that to happen? There are many. Could Donald Trump be one of them in some world? I pray not, for many, 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 many reasons. But the reason we're moving quickly, the reason the lawyers are getting into court is that the law compels congestion pricing. The plan was for it to be in place on June 30th. We've already spent $500 million on that infrastructure, and we need to see it in place just as quickly as possible. Let me invite some of the advocates up if they want to address the issue of talking to legislators. I mean, the answer is yes. We actually did a call last week with that included many of the state legislators who were the champions of and supporters of congestion pricing to give them an update of what's going on. There's some conversation about the possibility of one or more amicus briefs from legislators clarifying things about what their intentions were. But I also think you can see that from what Andrew Celli said, the law is quite clear, so there's not as much need to interrogate the intentions. The intentions are clear, and the law is still. Dialogue with them about the possibility of amicus briefs. The champions for congestion pricing in Albany who worked with advocates, who got it passed, who stood up during the budget session and refused the governor's efforts to derail or open it up again, are very much a broader part of our coalition and fully in partnership with us here. You know, I have never bought the argument that this jeopardizes the chances of Democratic House candidates. Some of them, like my friend, Pat Ryan, are opponents of congestion pricing and made clear. Some of them, like Tom Suozzi, who I was out there knocking doors for, support congestion pricing, and he won a swing seat while being a quite visible supporter of congestion pricing. As for what has happened since Sunday, I will say the elevation of Kamala Harris to being our presumptive nominee dramatically outweighs in enthusiasm for the fall anything, I think, that could be related to congestion pricing. And, as a matter of politics, not of this lawsuit, I'm very optimistic about our chances this fall. And I will just say we absolutely can implement congestion pricing before November and have favorable results on Election Day. There's continued research on that. As I say, the two areas where there's continued research going on are around accessibility issues and the civil rights issues related to the cancellation of elevator and accessibility projects, a very live and real issue. And we're looking at the bondholder and credit issues. Because congestion pricing didn't go into effect, there aren't yet specific bonds that were issued against the anticipated revenues from congestion pricing. However, there is reason for concern already that the cancellation could affect the MTA's credit rating and raise its cost of capital, and that might wind up having other implications. Those could be on additional operating or service cuts. And if that happened, then lawsuits like the one on buses might move forward as well. And if that materially impacted existing bondholders, that could go forward, but we don't have any immediate plans for that suit at this time.
I mean, is it correct to say that your office is helping to gather together the legal difference, strategy?
That's right. We convened the Legal Strategy Coalition, right when the governor announced the decision. A lot of folks here were doing the hard organizing work of, raising New Yorkers' cry, pointing out why, this is a giant mistake. We just started reaching out to people and convened a legal working group that includes the lawyers who are here and a few others, that includes some of the advocacy organizations who are here, so that it would be possible to sign a joint defense agreement and do research that could be shared and strategic on what are the key claims, should they be in one lawsuit or several, who are the best plaintiffs to bring them, divvy up that work, match lawyers and plaintiffs. Now, of course, on each individual lawsuit, the plaintiffs and their lawyers are the right people to ask questions about the specifics of that suit, but we'll continue to convene partners to make sure we're acting as strategically as we possibly can. I'm sorry, say again, $1 billion on what? It's a great question. I think the public advocate spoke to this as well. This is not a tax. It's definitely not a tax on the middle class, and I think it's important to make clear that for folks who commute all over the city, but especially into Manhattan for work, are overwhelmingly people who rely on subways and buses. And those are the folks who will benefit from the investments that congestion pricing will bring. For working New Yorkers, congestion pricing will have enormous benefits to make their lives easier. Even drivers, bus riders, taxi drivers, delivery workers are losing 100 hours a year to congestion on the streets. So congestion pricing will actually strengthen the city's economy, save people time if they're in cars or on buses, and it dramatically improve commutes for working New Yorkers on subways and buses. So this is a pro-working class, pro-middle class policy. In addition, reducing driving modestly will help enormously at cleaning our air and reducing congestion. This has been done by cities all around the world, and it's an effective public policy for reducing traffic, for cleaning the air, and for investing in transit. And we believe deeply that it will be good for middle-class New Yorkers, for working-class New Yorkers, and for the city's economy as a whole. I have not had any conversations directly with the governor about it. I have talked with MTA officials about the challenges facing them for their capital plan. I went to the MTA board meeting a couple of weeks ago. And many of us have talked with the legislators as well, who declined to consider a payroll tax and declined to pass any sort of IOU because they don't know what other revenue source there would be that could provide the resources necessary to the MTA. Obviously, none of them would have the benefits of traffic reduction and air quality improvements. And we can't wait until the 2026 budget. The MTA needs to produce its revised capital plan in October. And without congestion pricing and clarity about its revenues, they've already made clear they're going to cut 23 elevator projects, including in that station where a woman died in cardiac arrest carrying the stroller up the stairs, and 22 more. And through other cancellations, there is not, no one has identified another source. And we can't possibly wait until next year's budget if we're going to move forward with the capital plan. Congestion pricing is the law of New York State as a result of the MTA Reform and Traffic Mobility Act of 2019. the Climate Leadership and Community Protection Act of 2019, as you heard, mandates decision making that helps achieve emissions goals. What the lawsuits that are being filed today do is hold the state to the law. And I do think it's just important to understand that the core charge here is that the governor does not have the unilateral authority to cancel congestion pricing. It is the law, and that's why these lawsuits are being filed. Believe me, we wish we did not have to go into court to force the implementation of laws that were passed by the legislature, signed by the governor, and transparently require implementation. Good. All right. Great. Thanks, everyone. A shocking off-topic question. Obviously, today we're talking about congestion pricing. That is something I am continuing to weigh seriously, and I'll have more to say before too long. Thanks, everyone.